In an article by National Law Review, it was reported that Governor Gavin Newsom signed into law September 19, 2022, several measures relating to marijuana, including one that prohibits employment discrimination based on off-duty use of marijuana. The law takes effect on January 1, 2024. Though this ruling will certainly give many Californians cause to jump for joy, there are things that must be taken into account prior to celebration. While the law will prohibit an employer from discriminating against a person in hiring, termination, or any term or condition of employment if the discrimination is based on the person's use of cannabis being off the job and away from the workplace. In other words, this law would not allow for the equivalent of a smoke break for reefer smokers. The new law also does not prohibit an employer from discriminating in hiring, or any term or condition of employment, or otherwise penalize a person based on scientifically valid pre-employment drug screening conducted through methods that do not screen for non-psychoactive cannabis metabolites. An employer-required drug screening test that has found the person to have non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. The article also states that THC is the chemical compound in cannabis that can indicate impairment and cause psychoactive effects. After THC is metabolized, it is stored in the body as a non-psychoactive cannabis metabolite. These metabolites do not indicate impairment, only that an individual has consumed cannabis in the last few weeks. While there is consensus that an employee should not arrive at a worksite high or impaired when most tests are conducted for cannabis, the results only show the presence of the non-psychoactive cannabis metabolite and have no correlation to impairment on the job. So what we're looking at is the difference between having traces in your system versus being high. It further goes on to say that as science has improved, employers now have access to multiple types of tests that do not rely on the presence of non-psychoactive cannabis metabolites. These alternative tests include impairment tests, which measure an individual employee against their own baseline performance, and tests that identify the presence of THC in an individual's bodily fluids. The law does not further define non-psychoactive cannabis metabolites, and it is unclear what alternative tests are being referred to as tests that do not rely on the presence of non-psychoactive cannabis metabolites. While drug tests are being developed to detect recent use of cannabis, at the present time, such tests are not available. So, all in all, what does this mean? The good news is that for those who have had issues starting a job due to a habit shared by the masses, this definitely gives relief. There would be no more worrying about a dirty pre-screened drug test. Hopefully asking for family members' samples will end soon. But remember, as mentioned before, know that this law does not go into effect until 2024, and know that if you're flying high at work, this new change won't protect you. This is Big C's the Businessman. Take care of yourself, and see you next time.